Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video today, as the title suggests, we're discussing I-601 waivers. For those who are unaware of what an I-601 waiver is, there's another video on this channel, in fact, multiple other videos on this channel discussing I-601 waivers at some length. Suffice it to say, an I-601 waiver is utilized by those who are found to be inadmissible to the United States under one of the legal grounds of inadmissibility listed in the Immigration and Nationality Act. And if found inadmissible, the only real remedy for that inadmissibility is the use of a waiver. In most cases, it's an I-601 waiver. There are certain circumstances where what's called an I-212 may be necessary, but in most cases, a simple I-601, and they're not exactly the most simple things in the world, but a 601 waiver is going to be what's going to be needed to go ahead and overcome that inadmissibility. So basically this week, we got an approval on an I-601 waiver, and I was thinking about it after I had, sort of looked over the approval notice, and I thought to myself, we need to do a video about what happens after an I-601 waiver is approved. We discuss a lot about I-601 waivers with respect to what they're needed for and the reasons and findings of inadmissibility that they're associated with, but I never really thought about it. We haven't really done a video about what happens if they do get approved. I think there's a common misconception out there that upon approval of an I-601, the visa is sort of just magically issued. That's not the case at all. I-601 waivers, especially in cases where the applicant is applying outside of the United States for their visa, I-601 waivers are kind of a reversion, if you will, to an earlier phase in the process in that, and again, it's not exactly a reversion, it's a totally different process, but it seems like it to those undertaking this process as a whole. For those going through like a K-1 processing or the processing of like a CR-1 or an IR-1 visa, there's the initial petition being filed with USCIS. Upon approval there, you're going to either be dealing with National Visa Center or direct with the embassy in order to move the case forward through consular processing at a U.S. embassy or consulate abroad. Presuming that a consulate finds a ground of inadmissibility and that ground of inadmissibility is in fact waivable by use of an I-601, which that may or may not be the case depending on the finding of inadmissibility, the 601 is then filed, and then upon approval, what happens? Well, the case actually has to be sent back to the U.S. Embassy, or notification has to be sent back to the U.S. Embassy who made the finding of inadmissibility that in fact this finding, the finding of the inadmissibility is now waived, and that individual is now able to obtain a visa and travel to the United States. Essentially, there's another round, if you will, of consular processing that one needs to go through in order to finish up dealing with the visa and getting it issued. So, for example, in the time that it may have taken for an I-601 to adjudicate, and it can be a while, it can be anywhere from 6 to 18 months, maybe even longer, depending on the nature of the underlying case, if it's a contentious issue, et cetera, et cetera. Documentation requirements can be rather time-consuming. So these cases can take quite a while from the time of the finding to the ultimate issuance of an ultimate visa. And the reason for that is, in the aftermath of the 601 being approved, you may have to go back and reobtain things like police clearances and things like medical examination documentation, because all of that documentation may have gone sort of quote-unquote stale in the time it took to get the waiver issued. So there is a whole nother sort of process that happens on the back end of a 601. That being said, in most cases where the finding of inadmissibility has been waived, the process isn't particularly time-consuming, nor is it particularly cumbersome. It's just a matter of sort of going through a few more weeks of the quote-unquote motions to go ahead and get the document issued. And then once the visa is issued, because the 601 has been approved, that individual can travel to the United States rather freely and be admitted, notwithstanding a prior finding of inadmissibility.